Well, good afternoon, everyone. Good evening, I suppose it is in Mauritius. Thank you all very much for coming back. I'm sorry, I was having a little internet problem, not apparent to me, but only to the astute Lady Black this morning. But hopefully those have been cured. And now, Mr. Dunmeek, we are ready to hear you. We've decided that we should hear you on all issues, please.
Village, my first submission is that Article 340 of the Civil Code is a code unto itself, and it provides for, as my learned friends have said previously, 5 situations in which there is a gateway, there is a cas d'ouverture. And in this particular case, we had invoked the 5th limb, the 5th gateway, under Article 340, paragraphe 5. Dans le cas où le père prétendu a pourvu ou participé à l'entretien et à l'éducation de l'enfant en qualité de père. So it's not only where the presumptive father has provided, but he has participated also in the maintenance and the education of the child. Now, if, as in the present case, we come under the 5th limb, then the time bar which runs as from the date of delivery doesn't apply. Time only runs, as has been stated a moment ago, as from the cessation, as from the date that the presumptive father has ceased to provide for the child. And it was the case of the respondent in the courts below that the cessation happened in November, December 1999 with the demise of the deceased, that is, the presumptive father. And we also contended that time could therefore not run as from the date which appears on document P1, which is dated of 1995, and the main reason being that this is not the cessation of the father providing for the child. And the meaning of the participation will be found by your lordships in the judgment which is given by Mrs. Justice Debat, and that is to be found insofar as participation is concerned at page 550, which bears rereading in my humble submission. And your lordship will see that at page 550, her ladyship has reproduced the authority which I had cited to her at the top of page 550, and she states as follows: I find relevant the following extract from Juris Classeur Filiation Naturelle, fascicule 340, civil, article 340, cited by Mr. Domingue, which reads as follows: La participation peut avoir été faite soit à l'entretien, soit à l'éducation, soit à l'établissement. My learned friends have joined issue insofar as établissement is concerned. I shall come back to it in a moment. And it is said, sans qu'elle soit requise à tous ces titres à la fois. So it is not necessary that it should be cumulative. It may very well be disjunctive. Il peut par exemple être intervenu dans l'éducation de l'enfant pour payer les frais de sa scolarité, choisir l'établissement scolaire fréquenté. And in this particular case, we do have evidence that the presumptive father had a say insofar as the pre-primary education of the child is concerned, and also in the choice of the primary school. And in a moment, I will come to the conclusions of the Ministère Public through Mr. Jean-Louis, who has addressed all of these issues. But it is important to notice the concluding part of that citation, and this is to reply to the submission of my learned friend Itier. Il a même été jugé que la participation n'est pas nécessairement matérielle et pécuniaire, mais qu'elle peut aussi être affective et morale. And this is the conclusion which was drawn by the learned judge who tried the case, that throughout, since the birth of the child, the deceased had cared for her, had indeed considered her to be his daughter, and this until his last breath when he called for her. When he was on his deathbed at the hospital in Pamplemousse, he did call for her. And the child did visit him on several occasions when he was admitted at the hospital in December 1999. And it is also opposite to remark that at one point in October 1999, the child was sick. And at that particular point in time, the presumptive father, the deceased, had caused the respondent to be examined by Dr. Naik, who was his personal doctor. So this goes a long way to be able to find out what is the legal meaning of participation à l'entretien ou à l'éducation de l'enfant. So this is one of the authorities which I wish to place before your lordships. I also wish to refer to Juris Classeur at page 1707.
Yes, Lord Leggett has a question.
Yes.
Yes, Lord Leggett.
The authority which is cited in the judgment is talking about établissement, among other things.
Yes.
So does that indicate that it is in fact elucidating the meaning of the current French code, which, as we've been told, was changed, and that the Mauritian code is not in accordance with that? And so, whereas it's now clearly disjunctive, it was not clearly disjunctive before.
Yes, it is disjunctive, and the text of Juris Classeur refers to the position in France after 1972. That is clear because it refers to l'établissement de l'enfant.
Yes. So, in other words, it's not addressing the correct version of the code.
No, it's not addressing the correct version, but then my submission will be that when we turn to the authority cited by my learned friend Itier at page 2141, 2141, it is stated very clearly that under note 5, we read the following, which is very important. Antérieurement à la loi du 3 janvier 1972, that is before the French law of 3rd January 1972, la jurisprudence avait déjà parfois admis que la participation du père pouvait se réduire à un versement unique pourvu qu'elle ait un caractère important. So the previous case law, even prior to 1972, had recognized that participation of the father could be a sum of money, provided that it should be an important amount of money. And the authority is Requête 30 janvier 1934, Dalloz Hebdomadaire 1934, at page 180. So there was already authority, even prior to 1972, which supported the proposition that participation could also be a one-off settlement, provided that it should be a substantial sum of money. And when I turn to document P1, and I look at the amount and I convert it, it is presently stands to no less than 13.3 million rupees, which by any standard, whether a UK standard or a Mauritian standard, is a huge sum of money, which was meant to take care of the further tertiary education of the respondent. So that it is therefore my humble submission that on the authority which has been provided on behalf of the appellants, it is tolerably clear that even before 1972, the establishment of the child in such circumstances, especially if we look at the conduct of the presumptive father over time, since the birth of the child until 1999, we are bound to reach that conclusion. And it is also important to note that there was a conversation in 1995 without any document having been remitted to the respondent. Thereafter, it was only in August 1999 that the document P1 was remitted along with document P23. And we can see very clearly if we turn to these two documents, and if we compare these two documents, we will see that the first document, document P1, is dated of 1995. It refers to an account number and it refers to instructions that a fixed deposit be set up. And we have an account number which is provided on document P1. That account number is noticeably different from the account number which appears in the fixed deposit statement of account, and it is clear.
So we don't have the page number.
The page number is page 557, insofar as document P1 is concerned. And this must be compared and placed alongside page 602, which is document P23, to which my learned friend Iche had referred earlier on. And we see that the balance standing to the fixed deposit account as at 30th of July 1999 was no less than 266,981.26 pounds sterling. The account being a pound sterling account, which we can see at the top of the page. It is a fixed deposit, an account number is given, which account number is different from the one which appears in document P1, so that it is therefore tolerably clear that the instructions which were given in 1995 have been implemented, because there is now a fixed deposit which has come into being. But in accordance with the wishes of the deceased, he is the one who is managing the account until his death. And the total amount, as I have just stated, amounts to no less than 13.3 million rupees if it is converted at 50 rupees, Mauritian rupees per pound sterling. And that is a rollover in accordance with the instructions which were given. That is going to roll over, and therefore document P23 is consistent with document P1. But what is even more significant is that this document, these two documents, are handed over to the respondent by the deceased in the month of August 1999. And when that document is handed over to the respondent in August 1999, she doesn't realize the importance of that document, of these two documents. And when the document is remitted to her, it is 1 month later, after 30th of July 1999, 1 month after document P23 has come into being. And that document is only retrieved by the mother of the respondent when she finds it in one of the textbooks or copybooks of the respondent. And this prompts the legal advisors of the respondent to move for an amendment of the pleadings. And when we move for the amendment of the pleadings, to bring the action within the scope of the third limb to Article 340, we are met with an objection on the part of the counsel for the then defendants. But then the objection is waived, and the court does grant all the amendments which are made in pursuance of documents P1 and P23 without any objection having been raised. Rather, objections having been raised but dropped by counsel then appearing for both appellants. So it is my submission in that regard that the action was brought in a timely manner. There was no cause de déchéance. The statute of limitations did not apply because of the cessation, which was in 1999, take us to 2001, the action having been initiated in 2001. Had we gone on the fourth limb, the cessation of cohabitation, that would have been 1996, would have taken us to 1998 and would have been out of time. This is why we had to rely initially exclusively on the fifth limb, the cessation of the maintenance of the child and her education. And that took us to from 1999 to 2001. Now, there is authority which I have provided, and that will be found by your lordships under Dalloz at page 1994 of the bundle. And the relevant notes are notes 121 and 123. Lorsque la mère s'appuie sur la participation du père à l'entretien de l'enfant, il lui appartient, en cas de contestation, de prouver que les subsides ont cessé depuis moins de 2 ans. In this particular case, we had to move the court for the filiation of the child, insofar as the mother was concerned. We had to bring an action of contestation d'État, and the court did in favor, and it was declared that the mother was not Mrs. Abdool, was in fact Mrs. Gita Bandhu. Given that the mother could not act, we had to apply to the senior penal judge, who made an order that an administratrix should be appointed in order to bring the action on behalf of the child. Because we can see very clearly under Article 340 that the action belongs to the child. And during the minority, the action may be brought either by the mother or it may be brought by an administratrix on behalf of the child. And this is why an administratrix had to be appointed. And this was done by an order of the senior penal judge, which appears on the record of the court. And when that application was made, this being a matter of public order, the Ministère Public was joined as a party. And this was done following favorable conclusions on the Ministère Public that the action was brought under that particular limb. Now, I come back to page 1994. So, once there is cessation of the subside, si elle triomphe dans cette preuve, la jurisprudence l'admet à invoquer en outre, à l'appui de sa demande, un autre cas d'ouverture de l'action en recherche de paternité, ainsi l'aveu écrit du père. So this is why, in the midst of the proceedings, after the proceedings had started, And there was argument as to whether out-of-court statements of the deceased could be produced. In the midst of the proceedings, we moved that these amendments be brought so that we could also proceed on the basis of the third limb to Article 340, the aveu en écrit non équivoque du père présumé. And this is in virtue of the rule under Note 121, which further provides, en effet, la jurisprudence admet que si la demande a été formée en temps utile, en vertu d'un des cas d'ouverture visés par l'article 340, les autres cas peuvent être invoqués par la suite sans condition de délai. And what is even more important is to note down, is to go through Note 123. Les délais prévus par l'article 340 sont des délais préfixes. Ils sont d'ordre public. They are public order et ne peuvent être couverts par aucune renonciation. So contrary to the normal rule as to statute of limitations, the rule in this case as to statute of limitations is a matter of public order. It cannot be renounced, and it further provides ni retardé par aucune suspension. Cannot be interrupted or suspended. So that in this particular case, it was tolerably clear that first and foremost, the main question which had to be addressed up front was whether the action was barred by statute of limitations. If it was barred by statute of limitations, then the action there would have been a clause of déchéance. Because the law says very clearly in Article 340, this is the language of the statute, à peine de déchéance. And in this particular case, if I may take your lordships to the conclusions of the Ministère Public, and that will be found by your lordships as from page 533 onwards. Conclusions of the Ministère Public. The Ministère Public at page 533, 940, opine as follows. The Ministère Public is satisfied that paragraph 41C of the fourth amended plaintiff summons relates to paragraph thirdly of alinea 1 of Article 340. Paragraph B, paragraphs 2 to 5 of the fourth amended plaintiff summons relate to paragraph 4 of alinea 1 of Article 340. And thirdly, paragraph 46 of the fourth amended plaintiff summons relates to paragraph 5th of alinea 1 of Article 340. And furthermore, it was also concluded on the merits at pages 535 and 536 on the facts. Two issues were identified by the Ministère Public. Does the evidence show that the père prétendu a pourvu ou participé à l'entretien et à l'éducation de l'enfant en qualité de père? And the second question, has the action been entered within the 2 years following the cessation of the participation de la participation du prétendu père à l'entretien et à l'éducation de l'enfant? This is at the top of page 536. And both questions are answered in the affirmative for the reasons which are given, and in particular, and I read from line 17, it has further not been seriously disputed that Mr. Pierre Alican has participated en qualité de père in the pre-primary schooling of the plaintiff, bracket on the evidence of Mrs. Airbush. Furthermore, it came out, the cross-examination of Mrs. Gita Bendu, that Mr. Pierre Alican had participated in plaintiff's admission to Rajkumar Gajala School in Flak. And the relevant part of the evidence is identified. And furthermore, it has further come out of the cross-examination of plaintiff that Mr. Pierre Alican has regularly participated in plaintiff schooling, upkeep and maintenance, and the relevant pages are given. Furthermore, it has also not been disputed that the plaintiff spent school holidays and almost every weekend. Sorry.
I just wanted to ask what status these observations have. Do they have any legal status, or are they just argument by one of the parties?
No, it's not mere argument. Being given that this is a matter of public order, it is therefore mandatory that any authorization to start the action on behalf of the child by the legal administrator should be sanctioned by the judge in chambers. Once that is done, the main case, that is the action en recherche de paternité, must mandatorily be brought in the presence of the ministère public, because the ministère public is the guardian of public order. And this is why the conclusions of the ministère public always come at the end of the day. And conclusions are either favorable or unfavorable. And the reasons for the conclusions are given. Great weight is given by the court, as we shall see in a moment, in the judgment of Mr. Justice Devan. Great weight is given to these conclusions because the conclusions were favorable in certain respects, but then in other respects, the Minister Public was not willing that there should be an order that the respondent was the only other child of the deceased, because of the evidence which was on record and for the reasons which are given. And these conclusions have been followed in the judgment which was handed down by the learned trial judge in this particular case. And it is important also to note that at page 536, it has also not been disputed that the plaintiff spent school holidays and almost every weekend at the place of Mr. Pierre Alican. The relevant parts of the evidence has been identified up to around November 1999. And it was during those visits that Mr. Pierre Alican contributed to the upkeep, maintenance, and schooling of the plaintiff. And the conclusion, the action has been entered on 25th of April 2001, well within the 2-year prescription period. And the conclusions of the Ministère Public are favorable. But then under prayer C at page 537, for the reasons given, prayer C, the Ministère Public was not favorable to the order which had been sought, on account of the fact that the evidence shows that Miss Marie-Rosie Marjorie Iyasami is also the daughter of late Mr. Pierre Alican. We have not had the benefit of seeing her birth certificate or having any information as to whether she has been acknowledged. Accordingly, the conclusions are not favorable. And if I may...
does the minister receive representations from the parties before reaching these conclusions?
No, they don't. They don't at all.
So it's
they are
just a question.
answerable to the court. They conduct their own inquiry through the police by whatever means at their disposal, and they are bound to identify the relevant principles which are applicable. What are the principles of law? What are the texts which are applicable? Whether the matter has been brought in a timely manner. So they are the guardians of public order.
Quite. But
and this matter.
So the minister does consider the evidence, though.
Yes, he does consider the evidence.
Is that the evidence generated by the litigation, or is there some extraneous evidence to which regard?
It is the evidence which is generated by the litigation. It is the evidence which has been adduced on behalf of the plaintiff.
I see.
It is the evidence which is before the court.
Oh, quite. Right.
Can I just ask you, there's a reference to the cross-examination evidence of the December 13. So which cross-examination evidence does that relate to?
It relates to the cross-examination in the course of the trial. When the mother was giving evidence. Because the conclusions are filed after the close of the case.
Right.
And after the representatives of the parties have filed their written submissions in this particular case, and after oral submissions by counsel for the various parties. And if I may just refer very briefly to the sequence of events. First, appellant file written submissions, page 510, paragraph 16, 23, and 33. Oral submissions from the first appellant are at page 527, line 20. This was followed by written submissions by the second appellant at page 502. Oral submissions at page 529. And I myself, for the respondent, had filed written submissions, see page 497, and oral submissions followed at page 524. And thereafter, the Ministère Public, at page 535 to 536, filed its conclusions. And the judgment was thereafter given by the learned judge. And your lordships will see when we come to the judgment itself that Her Ladyship has in fact referred to the conclusions of the Ministère Public in this particular case, especially when it came to the question whether the result of the DNA investigation in pursuance of Section 8 of the DNA Identification Act is that a fin de non-recevoir. And the conclusion of the Ministère Public, which is similar to my own submission, is that this is not a fin de recevoir, fin de non-recevoir, and it cannot be construed as a fin de non-recevoir. And
presumably the conclusions of the minister are not binding on the judge.
no, they are not binding.
Not binding. Well, what
They are not binding, but considerable weight would be attached to the conclusions of the Ministère Public, both before the court of trial and before the appellate court also, because the Ministère Public was represented by counsel on appeal, and submissions were offered by the Ministère Public insofar as the request for exhumation was concerned, for the post-mortem DNA identification. Mr. Mitouk was counsel before the Court of Appeal, and he did offer submissions. In the present case, the Ministère Public has said very clearly that it did not wish to take part in the present proceedings, but it is at the disposal of your lordships in order to enlighten the board should the need arise. And,
yes.
and generally, the conclusions are based on the law and also on the evidence which has been adduced before the court of trial.
Yes.
I find comfort in my own submissions and those of Mr. Jean-Louis for the Ministère Public at page 2092 of the electronic bundle, where there is a reference to the former Article 340, fifth paragraph from the bottom. Or, dans un arrêt de principe, la Cour de cassation avait déduit de l'ancien article 340 que la paternité au mariage ne pouvait être déclarée que dans les 5 cas qu'il énumérait limitativement. So this is common ground. There are only 5 gateways and there are no other. And then we come to the next paragraph, même si l'on pouvait déplorer le caractère désuet de l'ancien article 340, le raisonnement suivi par l'arrêt critiqué et cassé constitue assurément une hérésie juridique. And I come to the important part. En effet, d'une part, aurait ainsi été créé un sixième cas d'ouverture à l'action tirée de la preuve de la certitude biologique de la paternité, alors que le législateur de 72 avait voulu limiter le domaine de l'action en dépit de la valeur qu'il avait entendu attachée à la vérité biologique. So, in other words, even when we come to 2010, and in 2010 comes into force, into application by proclamation, the DNA Identification Act, I cannot possibly bring an action en recherche de paternité until and unless, and I cannot therefore ask for DNA identification to be carried out, either by consent of parties or by order of the court, unless I come within one of the 5 gateways. Section 8 of the DNA Identification Act is a piece of adjectival law. It is not substantive law. It doesn't create a 6th category. If I do not come within one of the 5 recognized causes of action, which is maintainable by law, that this is the question of recevabilité and fin de non-recevoir, it is only then that I can invoke Article 8. And Article 8 is to be read, obviously, in conjunction and subject to Article 340 at page 1589 of the bundle. We have reproduced Section 8 of the Act. DNA sample to establish filiation. Notwithstanding any of the provisions of this Act, a forensic analysis for the purpose of ascertaining filiation under the Code Civil Mauritius may be carried out by the FSL, where there is an order from a judge to that effect, or the relevant parties consent to provide the sample, and on payment of such fees as may be prescribed. But the important part is that this forensic analysis is for the purpose of ascertaining filiation under the Code Civil Mauritius. If I do not come, therefore, under the umbrella of the one of the 5 gateways, which are limitatively set down, I cannot possibly ask for such an examination. And that examination is focused upon ascertaining filiation. And this is why, in the present case, I had to cross-examine the maker of the report in order to focus upon the context in which this report has been made. It is not a filiation test as such. Had the report come to the conclusion that the respondent and Appellant Ibrahim were half siblings, that would have shortened proceedings tremendously. But when the conclusion came that it is a very remote possibility, that was not the end of the case, because it was not a fin de recevoir, de non-recevoir, nor was it scientifically established that by reason of the fact that the deceased had gone to the civil status office and acknowledged Ibrahim as being his son, that it did not follow therefrom that it had been scientifically established that he was in fact the biological son of the deceased. And this is why, after having considered my position, I informed the court that I would have to proceed with the case nevertheless. And this is why I had to cross-examine the scientific officer in order to focus upon the weight to be attached to that particular report. It's not an analysis which could have ascertained the filiation. The report was inconclusive. It might have concluded the proceedings, but in the circumstances of this present case, it was inconclusive insofar as the question of who is the father of the respondent.
Well, when you say it's inconclusive, as has been pointed out, a DNA examination does not purport to produce a result of infallibility, which cannot be challenged. But the DNA report in this case, if properly prepared and scientifically underpinned, certainly pointed very strongly in favor of the proposition that the respondent was not a sibling or a half sibling of Ibrahim, didn't it?
Yes, that is indeed conclusive in that respect, but it does not follow therefrom. It does not follow therefrom, in my humble submission, that the deceased could not have been the father of the respondent, unless there was clear scientific evidence that the appellant Ibrahim was the biological son of the deceased.
Well, quite. But leaving that possibility aside, the report could hardly be characterized as inconclusive, could it?
Well, I would submit that
it was fairly conclusive about the remoteness of the possibility that they were half siblings.
Yes, in that respect, yes. But then the issue was not about their being siblings. The issue was about filiation. And in that respect, I respectfully submit it was inconclusive in that respect. And therefore, the court had to consider the evidence before it and to see whether we had established our case on the basis of the third and fifth limbs. And this is where the document P1 and document P23 weighed very heavily in the equation. And in that document P1, we can see that on no less than 2 different occasions, the deceased has been referring to the respondent as being Piradicant, also known as Piradicant. He refers to a place of birth. He also refers to the date of birth. And it is my humble submission that this satisfies all the conditions of an aveu non équivoque de paternité. And this is a matter which has been lengthily considered by a ladyship in the court below. And I would wish to refer your lordships to part of a judgment where she says very clearly in that part, a ladyship referred to the report which had been filed by Mrs. Boudard, and we can see that this is to be found at page 541, starts at page 541, and it goes up to page 543, top of the page. And the relevant parts are to be found at page 541, the last paragraph. It is appropriate to go back in time when Mr. Domingue moved for an order, and she reaches the conclusion on the basis of what Mr. Jean-Louis says. This is at page 542, that it is not a fin de non-recevoir. This report of Boudard is not a fin de non-recevoir. And on appeal, this conclusion is not being impugned. This is an important consideration. Had it been a fin de non-recevoir, that would have been an end to the action of the respondent. And furthermore, her ladyship, having reached the conclusion, assesses the weight to be attached to that report. And this is to be found at page 542 in fine. Because in that particular case, she says, in view of our evidence that a sibling test is a last resort test when all other types of tests such as paternity, maternity, and biochromosome have been exhausted, that a sibling test is not as conclusive as a paternity test on account of its complex statistical calculations. And thirdly, further evidence that although the forensic science laboratory is equipped to carry out DNA tests, it was the first case, sorry.
Yes.
The sentence that begins secondly says, secondly, the findings of Ms. Goodall also have no bearing on the issue of non-recevability.
Yes.
Doesn't that make it clear that what the judge is addressing in this paragraph is the question of the whether the evidence is inadmissible, as it would be put in English, rather than the question of what weight should be attached to it if it is admissible?
Well, the way the sentence the way it has been written might give that impression, but then I had cross-examined insofar as the weight to be attached to that report is concerned, and I can only point to page 1116 in that respect, which may shed some light on the matter. 1116, where the court had observed, at the end of the day, it will be for the court to decide what weight to give to evidence to the FSL report. This is to be found 7 lines on the bottom. This is when Ms. Nusrat Begum, the respondent, was being cross-examined by my learned friend Sibati. And there is that observation of the court. At the end of the day, it will be for the court to decide what weight to give to evidence to the FSL report. And
yes,
it is
well,
my humble submission.
whether, as Lord Leggett says, the expression used by the judge, no bearing, is to be interpreted as meaning, in effect, that it was inadmissible. At the very least, it means that the judge decided that no weight should be attached to that evidence. I mean, is that a defensible position? And surely some weight must be attached to it.
Some weight must be attached to it insofar as it shows that these two children are not half siblings. But does it go and support the case for the appellant that she cannot therefore be the natural daughter of the deceased? That is a different matter.
Well, it certainly has some bearing on that question, doesn't it?
Well, it does bearing, but as I said, it is not conclusive. It is inconclusive insofar as the main issue is concerned. Unless one is satisfied there is sufficient evidence from which one may conclude that the acknowledgement of the child by the deceased is conclusive evidence that he was the biological father.
Right, but there is a spectrum of possibility here. On the one hand, it may be regarded that this evidence, taken with the other evidence that Mr. Pir Ali Khan had acknowledged Ibrahim as his natural son, did in fact establish that your client could not have been his natural daughter. That's one possibility. At the other end of the spectrum, it would be open to a court to say, well, this is evidence that must be taken into account. But considering all the other evidence about the support that he gave to his putative daughter and the fact that he set aside money for her future education and so on, and called for her at the time that he was dying, that all of that establishes that the weight to be attached to the DNA report is commensurately less. but it certainly wouldn't open the possibility for the judge to say this has no bearing whatever on the issue, would it?
Well, insofar as the issue of filiation is concerned, this is my understanding of that part of the judgment. When she refers on the issue of non-recevabilité, saying that this report does not set the action to naught. This is what she is saying. That is not the end of the action. This doesn't determine the issue. That possibility is still open. And I have therefore to decide on the merits, whether on the basis of alinea 3 and alinea 5, that there is sufficient evidence for me to conclude that the presumptions which have been enacted in the statute, whether they are satisfied in this present case. And she relies very heavily on the totality of the evidence, that is from the birth of the child until 1999. And she gives considerable weight to document P1, and she concludes that this is an aveu non équivoque de paternité, because an aveu non équivoque, sorry.
Yes.
Yeah, Mr. Domain, as I understand it, this DNA report, a court order for this report, was obtained from the court on your application on the basis that the court was told that it was common ground that Ibrahim was indeed the son of the putative father. Now, you presumably received the report months before the trial started. Did the trial itself start with no attempt on your side or anybody else's side to step back from that common assumption about Ibrahim's parentage upon the basis of which the report had been obtained? I should say we've been shown your submission about it, but was anything done before the trial started to undermine what the court had been told was common ground?
Well, nothing had been done before the case started. When the case started, we had started with the admissibility of the out-of-court statement of the deceased, Mr. Piralican. And the court had reserved an interlocutory judgment. Thereafter, we came across document P1, and then we decided that we would have to move for an amendment, because we would also have to invoke the third limb to Article 340. And thereafter, in the midst of the proceedings, given that by 2010, when your lordships will look at the DNA Identification Act, it only came into force in 2010.
So, I was asking about the trial itself.
Yes.
Mr. Domain, when the hearing, was there a single hearing before the judge by way of what we would call a trial, or was it a series of separate staged hearings dealing with different aspects of the matter?
There was a first part of it, which was before the Fourth Amendment.
Yeah.
And that was up to a point where there was an objection to the admissibility of the out-of-court statement of the deceased following the police inquiry. And thereafter, the respondent had turned 18, she became of age, and therefore she was substituted as the plaintiff. And thereafter, the case unfolded at one go, and all the witnesses were heard, starting with Mrs. Eabu, Mrs. Gita Bandhu, and the plaintiff herself, and the other presumptive half-sister. All of them were heard, and I had moved the court, because it was by then after 2010, and the act only came into application in 2010. I had then moved for that particular order in the belief that this would assist in ascertaining the filiation. But at the end of the day, it was not a fin de non-recevoir. So we had to go back to the evidence which we had insofar as the legal presumptions of law are concerned. And we had to go back, therefore, to the evidence which was available.
But as I understand it, am I
Pardon?
right in thinking that nothing was done on your side until your closing submissions in writing and orally to put in doubt the previously common ground that Ibrahim was the deceased son?
Well, we didn't put it into doubt at all before.
No.
No, we didn't put it into doubt because we assumed, and with hindsight, I'm now saying we assumed wrongly that he was the biological son.
Mm.
So everyone acted on that assumption.
Yeah.
But when I look at the totality of the evidence, such an assumption, according to me, was wrong, was erroneous, because it was not established scientifically that he was in fact the biological son of the deceased. And it is important to note that the presumption of law as to who is the father applies in the case of a married couple. The law presumes
Yes.
that the husband is the father of the child. In this particular case, there is no such presumption. We only have the fact that the deceased, in the belief that he was the father of the child, he went to acknowledge the child. But can we therefrom say affirmatively that he was in fact the biological father? That is a different proposition. And as I say, we based ourselves on an assumption which turned out, according to me, not to be correct.
Yeah, but I think Lady Black has a question.
Thank you. The first one is a factual matter. I think I've seen a reference in a transcript to a discussion between, I think, you and the judge orally about whether Ibrahim was acknowledged to be the natural son or not. So if you can at some point give us the reference to that, that would be helpful. The second is going back to the question we were on before we diverted slightly, and that is what the judge did about the DNA evidence. You've shown us the passage in the judgment, all of which is under the heading of non-recevability. And the judge doesn't come back to the question of the DNA evidence, I don't think, thereafter. Now, I wanted to know what your case was. The bases within Article 340 give rise to a presumption, I think, don't they, of paternity. That can be rebutted. Is it open to those who wish to rebut that presumption to rely upon DNA evidence?
Well, it is not expressly provided for under Article 340.
No, it's not a non-recevability question, but can that material be used otherwise to feed into the question of whether it has been established that the presumption doesn't apply?
Well, if that may be read into Section 8 of the DNA Act, it might be construed in that way. But as I say, it is not one of the three fins de non-recevoir. There are only three fins de non-recevoir which are clearly established under Article 340.
So is it your case that DNA evidence, if it fails at that stage, cannot be taken into account by the court?
DNA evidence may be taken into account by the court if it is a comparison and identification between the presumptive father and the claimant. The court will be bound to take it into account. And this is the whole purpose of having, since 2010, the DNA Identification Act, which must be read in conjunction with Article 340.
So
this is why there was this motion, which was made.
Yes, right.
At that particular point in time.
So is your case that it cannot, however, be taken into account when it is a lesser relationship that's being tested?
That's it. This is my case.
But it cannot be
This is
taken
my
into
case
account.
because it has no bearing on filiation. It is
Right,
only
so
a
it
half
can-
sibling. Sorry.
So you're saying that it's correct of the judge to have left the whole of the evidence out of consideration at the stage of looking at the matter on the basis of sociological and other evidence.
Yes.
Right. And the Court of Appeal didn't see it that way, did they? I thought the Court of Appeal saw it as if she had in fact taken it into account.
Well, she had examined it under the umbrella of recevabilité. But then, when we look at the latter part of secondly, although she refers to non-recevabilité, she refers to my cross-examination as to the weight to be given to that report. And is that report geared towards filiation? That is the nexus between the deceased and the claimant.
I have a problem, Mr. Doing. If, as you submit, a sibling test rather than a test of the putative father's DNA is not admissible for the purpose of challenging whether a claimant has satisfied one of the 5 gateway presumptions in Article 340, why is it admissible for the purpose of bolstering it? After all, it was you who went to court to ask for a court order for a sibling test on the basis that it would assist in the proceedings. How can it be admissible if it helps you, but not if it doesn't?
Well, it would have assisted if it could be shown that the father was the same, they had the same father. Then would have assisted us. But since the report in that respect did not show that they had the same father, the question still arose. Is the respondent the daughter of the deceased? Because there was no scientific evidence to establish that the first appellant, Ibrahim, was the biological son of the deceased. And as I said,
I'm sorry. I think my last point is this: if it would have established that Mr. Pir Ali Khan was the natural father of your client, when the DNA test failed to show that, it's surely relevant to the question whether or not she was the natural daughter. It may not be conclusive, but it's surely relevant.
Yes, it is relevant. It has got to be considered in the round with the totality of the evidence.
Yes.
And of course, in the light of my cross-examination, in order to focus upon the purpose of a half-sibling test.
Yeah.
Does it assist in...
Lord Leggett, I think, is the question, but just before I invite him to ask the question, I think the passage that my lady was referring to is at page 474 of the electronic bundle, in lines 30 and lines 40, lines 30 and 40. But in the meantime, Lord Leggett. Yes, Lord Leggett.
In the judgment on page 548, there's reference to the testimony of Ibrahim's mother, that she was indeed his mother. And I just wondered when that testimony was given, whether it was oral evidence, whether it was given after the DNA evidence was available, and whether you challenged or at least contested that evidence.
That is an evidence which was given before
Before
the motion for the DNA.
Right. Thank you.
Yes.
We had already called the biological mother, had already been called and heard by them.
I see.
And we wanted to ascertain whether we could buttress the case given the new legislation, would it assist in any way? But at the end of the day, the conclusion which is arrived at, and this is on the basis of my own submission and the conclusions of the Ministère Public, is that the DNA report is not a fin de non-recevoir. It doesn't put an end to the action. And one must go one step further. Should one therefore put in the balance the DNA on the one hand and the other evidence, which in my humble submission is not sociological indicia, as has been stated by my, this is the submission of my learned friend Iche. These are presumptions which are laid down in Article 340, that if there is an aveu non équivoque, if the presumptive father has provided as a father towards the education and maintenance of the child, the court may reach that conclusion. These are presumptions which are to be found in the law itself. So these are not mere social indicia. When we start off with Mrs. Airbu and we end in December 1999, these are not mere social indicia. We are establishing very clearly, and the court found that it was on a preponderance of evidence, the nexus between the deceased and the respondent, including the fact that the 9th birthday was celebrated, the fact that she was under the same roof until the separation. And we have all these photographs. We have the photograph taken, the child and the mother, together with the deceased. We have this 9th birthday, which is celebrated at Belmar, with several photographs. And we also have the fact that when there is this separation in 1996, and there is the cessation of the cohabitation between Gita Bandhu and the deceased, what does the deceased do? It takes away the child. Then the police is called for. And at that particular time, your lordship will see that there is a police inquiry underway. The child protection unit is brought in. Statements are recorded from the deceased. And in one of his statements, he says very clearly, she was calling me father and I considered her to be my daughter. This is said very, very clearly in that defense statement, which is recorded from the deceased. And I shall refer your lordships to that part of the evidence. And it is clear that this is stated by him as a result of questioning by the police. That is in part of his defense, which were recorded in Creole, and we do have the translation which has been put up, to which I shall refer your lordship to the last part of that statement. So this is the relevant part. This is the translated version at page 1163. And it is a statement which is given at the Port Louis South CID on the 16th of May 96 by Mr. Piralican, recorded by Police Sergeant Elapen, signature witness Detective Inspector Sibala, page 1163. It is the concluding part which is important. When Nasrat Panon Abdool, that is the respondent, was living at my place, I was caring for her as my own child, and she was calling me father and Gita mother. So that in my humble submission, when we turn to the third and the fourth gateways of Article 340. We are putting under a microscope, if I may put it that way, what is the conduct of the defendant or of the presumptive father? What has been his conduct throughout, since the birth of the child? And we have also adduced evidence in regard to the prenatal care also. He was the one who was present at the birth. He paid for the delivery at the private clinic. And throughout he was residing with the biological mother of the respondent. And my learned friend Jean-Louis, in his conclusions, says that part of the pleadings do refer to the fourth limb. And we have authority that if the action has been brought tenuously and the fifth limb, then it is possible at a later time to rely on the other limbs also. And what is also of some importance is that in the conclusions of the Ministère Public, to which I referred a moment ago, it is also stated that the second part of the statute of limitations, which applies after the child becomes of age, we could not possibly in the same proceedings rely on the fact that the proceedings ended after the child had become of age, because of the conclusions which have been filed by the Ministère Public, based on French authority, that it is in the same instance, it is in the course of the same proceedings which had been started during the minority. If the proceedings end after the child becomes of age, that will not assist if the proceedings were time-barred right from the start. And your Lordship will see that this is to be found at page 534 under line 20. And this is what we may find from the conclusions of the Ministère Public. For all intents and purposes, therefore, the plaintiff continued the action entered by Mrs. Binda Ganga upon plaintiff attaining a majority. Action had been started by the legal administratrix appointed by the senior penal judge. This is not a case where the action entered by Mrs. Ganga was foregone and a new action was entered by the plaintiff upon plaintiff attaining majority. Therefore, the prescription of 2 years following plaintiff's majority provided for under alinéa 6 does not apply in this case. We find support for this proposition under Juris Classeur. La loi n'ouvre toutefois ce nouveau délai à l'enfant qu'autant que l'action n'a pas été intentée pendant sa minorité. So there was one set of proceedings which had started during minority, which was concluded when the child became of age. And the action could only be maintainable under limb 5. But thereafter, we could invoke other grounds. This is made terribly clear by the laws. And this is what we sought to do, to bring in, therefore, this additional averments after document P1 had been recovered. We had to place it before the court, and before placing it before the court, in the midst of the proceedings, we had to move to amend the pleadings drastically. And this was done without any objection being taken. Had we been out of time, I would have expected the objections to be maintained. The fact that the appellants at that point in time did not maintain the objections to the amendment being granted and reference being made to document P1 can only be construed in these circumstances as being an acceptance of the fact that the proceedings were not time-barred. Because we could not possibly have brought in the third limb to Article 340 if we were already out of time. And at the relevant time, we can see from the record that one of the respondents was being represented by senior counsel, my learned late friend Motokyo, QC appeared for one at the relevant time, and he did not insist on his objections. And the court therefore granted the amendment, and we have now therefore the fourth amended plaint in the form in which we see it, with all of these various amendments, so that it is therefore my humble submission that we did whatever we could do in these circumstances. We went under the umbrella of Article 340. When the new law had come into force, we moved that there should be such an exercise, because we assumed that he was indeed the biological son of the deceased. And it is my humble submission that insofar as filiation is concerned, the issue is still open. And when we consider the whole matter in the round, we do find that there is preponderant evidence from the even before the birth up till the date that the presumptive father passed away in 1999. And there was clearly an intention on the part of the deceased as from 1995. The child was then 5 years old. So he had decided to set some money apart, which is going to be under my control. After my death, this sum of money will devolve to her, and the intention was that to provide for higher studies. And in that document, he refers to her as Pierre Alican, also known as Pierre Alican. Why would he refer to her as Pierre Alican if he did not thereby intend to convey to any reader that I am treating her as my own daughter and I want to provide for her? So long as he was still alive until 1999, the funds were under his control. And why does it decide in August 1999 to hand over the document to the respondent? Presumably because he felt that given his state of health, that it was advisable that he should do so. There is no other inference which may be drawn from this set of facts. And we must also not be oblivious of the fact that there was an attempt made by one of the respondents in this case to mislead the court by bringing in a document D28. They sought to water down document P1, and eventually they had to concede that it was a forged document. That document was put in by my friend Sibachi, but then at the end of the day, if we look at this document, is in my humble submission is of some significance in this case, and it shows to which extent they were prepared to go in order to try to pervert the course of justice.
Well, I wonder how relevant this is that we have to decide in various. I wonder how relevant this is to the issues that we have to decide. And various tactics are deployed on behalf of parties, which may or may not be creditable, but ultimately we've got to decide whether or not the issues have been established, not to make to pass a judgment. It's not primarily to pass a judgment on the techniques employed by counsel who represent the parties. But anyway, take us to the document, but perhaps limited reference to it would be appropriate.
This is at page 623.
Sorry, say that again, please.
The document is to be found, it is D18.
Yes.
D18, and the document is to be found at page 623.
Yes,
The
thank you.
document was put in by counsel. Thereafter, it could not be sustained. And it contains a signature which was attributed to the deceased, but which in fact is not that of the deceased.
I see.
And this had to be acknowledged that they could not proceed on the basis of that document. But that document had been placed before the court. And it is only after I had drawn attention to the fact that this could not possibly have emanated from the deceased, and that I would have to recall Mr. Raja for that, in order to shed light on that particular document. It is only then that this was given up.
Yes, I see. Well, now,
Therefore, important
I'm
to
sorry,
consider
I'm sorry to interrupt again, Mr. But you only have a few minutes left, and we would be interested to learn of any submissions that you have to make against the proposition that if we decide that the appeal should not succeed outright, that we should remit the case to deal with the whole question of whether Ibrahim was indeed the natural son of Mr. Pierre Ali Khan. Do you have any submissions to make about that?
Well, in that case, it will have to be considered in the round. We will have to consider the matter on the merits. We will have to weigh in the balance, on the one hand, the DNA report and the rest of the evidence.
Yes.
And what is the weight to be attached to that particular to the DNA identification report? I had already cross-examined quite lengthily, and I had focused on a number of matters to show to the court that this was no substitute for a filiation test. And this is presumably why, on appeal for the first time, the question of exhumation was mooted. This was not a matter which had been mooted earlier on, bearing in mind that the deceased had passed away since December 1999. That is 21 years ago. And it is also significant to note, and this is why I had made a note of it in my written submissions, that insofar as the other adopted child, they had declined that there should be an identification test, a DNA identification. That might have assisted also, but they were not willing to do so. And I was not prepared to ask for an order to be made in that respect. And the question has also been asked, are there other siblings of the deceased? There are none we know of. Otherwise, in accordance with Section 8, a motion would have been made in that respect. And your Lordship will also see that in the DNA report, when it comes to the of both children on the mother's side, it merely says we cannot exclude that Gita Bandhu may be the mother. We cannot exclude that the other lady, Mrs. Piabak, maybe the. So there is nothing conclusive in any of these DNA reports.
Yes. Thank you.
There's one question I'd like to ask you before you finish. You took us at one point in your argument to page 1163, which is the end of a statement made by the deceased, Mr. Pierre Ali Khan. I wanted to know if that statement was in evidence in the proceedings or not, because the bit you referred us to, it looked a bit strange to me that he said, I was caring for her as my own child. And when I looked earlier in the statement, I see that it's full of evidence explaining that she's not in fact his child and that he never had a sexual relationship with the mother.
Yes, this is what precedes. But at the end of the statement, he must presumably have been questioned by the police, and then he gave that answer.
Well, that answer just means he was treating her as though she was his child. although in fact she wasn't.
He
But was
was
it in evidence at the trial, or did you successfully exclude it from evidence?
Well, that was an out-of-court statement by the deceased to the police, and we wanted to rely on that part of the statement.
Oh, you did.
But it's true that he had denied being the father of the child. That is a fact.
But was it put in evidence? Was it put in evidence, the statement?
The statement was put in evidence, yes.
No.
The statement was in fact produced by the defendants in this case.
Yeah.
This is a translation from the Creole language. The original statement will be found by your lordship at page 614. Page 614, we have the original text. And,
Mr. Domingue, on the previous page at 1162, it appears that Pierre Ali Khan is saying he doesn't even know who Nusrat's mother was.
no, he said that she was residing with him.
But he says he doesn't
Child
know
has
the mother of.
grown up under his roof. He said that
Yeah,
he knew her, he met her. He said that she was residing with him. And we do have photographs. We have a photograph which shows that the three of them together, the child in between, together, the deceased, the child, the respondent, as well as the Gita Bandhu. There is a photograph, a color photograph. That was before the separation. And we also have several photographs. And this particular photograph, non, les trois là avec la maman. Page 611, we have got the father, well, the presumptive father, rather, page 611. But then there is a photograph where we can see Mrs. Gita Bandhu together with the child and the deceased. This is at page 604. No, c'est pas ça. La maman. 604, this is the birthday ceremony. L'autre photo, we are.
But he doesn't deny living with the mother. He just gives an account of how the mother asked if they could look after a child that he didn't know who it was.
Well, there is evidence where you have the three of them who are together.
Mm.
There is that photograph, which was placed before the court, and that was before 1996. This is in 1996 when they broke apart. But then we can see the photograph of the girl when she was still a toddler. So relevant. So if we turn to page 583, page 583 is a color photograph where you see the deceased on the right, the respondent in the middle, and Gita Bandhu on the left.
Yes.
Mm.
So he could already say that he already knew the mother. He had written to the mother. There was a postcard from Paris. They were friendly. Then it developed into an amorous relationship. This is recited in the judgment of her ladyship. And then they started cohabiting together in Portlaoise in a flat at Majestic Cinema. And when she became pregnant, they went to reside at the place of the deceased in Flack. Then he provided for the prenatal care, he provided for the delivery, he paid the clinic. And they were living very happily together. And I may refer, for example, to page 581, the picture of the child in Flack. Page 580, again, the child in Flack. She's on a bicycle. We can also see the photograph at page 582. We
Yes.
can also see the various letters of condolences, page 586 onwards, as well as the jewelry, which according to Mr. Gita Bandhu has been showered upon her by the deceased. This is at page 585.
Yes, thank you very much indeed, Mr. Drummond. I'm afraid that exhausts your time, but we'll consider these submissions very carefully indeed. Thank you very much indeed. Now, Mr. Ifye.
Yes, my lord. I shall be very brief, and I shall put in the statement which the late Pierre Alicant gave to the CID. It starts with his acknowledgement of Ibrahim. He says, some 22 years ago, I had contracted Muslim religious marriage with a woman called Amina Pierbux, and I was living with her at Mauritius. From our union, a boy was born, and whose name is Ibrahim, and I have acknowledged him, and I have given him the name Ibrahim Bialika. And secondly, Mrs. Gita Bandhu, that is the mother of the respondent, also, in fact, twice, under oath, accepts that Ibrahim is the acknowledged son of deceased. This is to be found at page 1041. 1041. When she is cross-examined by Mr. Sibati, who was then counsel for Muhammad Fuad, and he asked about on the 10th line, well, it appears that you have said certain things, and I have to ask you the question. Mr. Ibrahim Hossein Ali Khan is the acknowledged son of Mr. Pierre Ali Khan. Do you agree? And she says, yes. And then in an affidavit sworn by her in the course of other proceedings at page 595, she again stated at paragraph 16, at page 595, paragraph 16, she stated that after the death of the late Pierre Ali Khan, he left as sole heirs and parties entitled to apprehend his estate and succession a natural acknowledged child named Ibrahim Hossein Ali Pierre Ali Khan. So we have all this evidence in favor of the version that Ibrahim is indeed the acknowledged son of the deceased. And in fact, the deceased as well has accepted this, both in the statement to the police and at page 1163 as well. And your lordship is quite right to have drawn the attention of my friend to the fact that he said that he didn't know the mother of Nusrat Banu Abdool. What I understand by that is that he doesn't know whether it is Gita Bandhu or whether it is Fazila Abdool. So he doesn't know really, this is what he says. And finally, I would like to add that the testimony of Ibrahim's mother, Mrs. Pierbux, occurred after the reports of the FSL had been filed before the court. I think that's all I have to say, my lords. Thank you.
Thank you very much indeed. Now, Madame Devaux de Marigny. Yes.
Can you?
Madame?
My lords, thank you very much indeed for bearing with me. Trying to connect it. We have a
1 second, please. We are not on the website anymore. I think one of you needs to turn off their speaker so that Angelique can speak without any feedback.
We're not sorted. So, my lords, there are basically 3 points which.
Sorry, apologies for disturbing you, Angelique. We cannot see you at present, and there is a warning symbol against your profile.
What do I do, Brian?
Are you able to turn on your video, please?
Yes. Here we go.
Well, ironically, we could see Madame Devaux de Berigny, but anyway, we can see her now again. So let's hope it proceeds smoothly
Can you
from
see
now on. Yes, we can.
Good. So I was about to say that there are 3 issues on which I would like to address your lordships very briefly. Concerns the provisions in the Mauritian Civil Code on acknowledgement of a natural child. These provisions are to be found in the Code Civil in Article 334, which you can find at page 1407. So if I may,
which page, please?
1407, my lord. 141407.
Oh yes, thank you.
Provides as follows. La reconnaissance d'un enfant naturel sera faite par acte authentique lorsqu'elle ne l'aura pas été dans son acte de naissance. In other words, there are 2 ways of acknowledging a natural child, either before a notary in an acte authentique or simply in the act of birth. We know in the case of time, but it is in the act of birth that the acknowledgement is made. Further, at page 1407, Article 338 provides l'enfant naturel reconnu a les mêmes droits et les mêmes devoirs que l'enfant légitime dans les rapports avec ses pères et ses mères. In other words, there is no discrimination if a child is born within a marriage, within wedlock, or outside wedlock, if he has been recognized, if he's been acknowledged. Finally, Article 339 provides toute reconnaissance de la part du père ou de la mère, de même que toute réclamation de la part de l'enfant, pourra être contestée par tous ceux qui ont intérêt. In other words, every acknowledgement can be challenged by those who have an interest to do so. So much for the first. The second point is in reply to a question by my Lord Briggs, about the chronology of this very, very long hearing. So, in fact, there have been 7 different hearings on the merits in this matter. The first day was on the 12th of July 2011. On that day, Mrs. Madhav Dasan was called. She was the initial forensic expert. January 20, Mr. De Raja, the attorney who witnessed document P1, was heard, and Mr. Kirpan from the Immigration Office was called. On the third day, 1st of March 2013, Gita Bandhu, the mother of the plaintiff, was called, examined. On the 4th day of the hearing, on the 30th of May 2013, the cross-examination of Gita Bandhu, which had been reserved, was continued, and then Nushrat was called, Brinda Ganga, the administratrix, was called, Rosie Iyasami, and finally Afiza Pirbut, Ibrahim's mother. On the 5th day, 10th of October 2013, it is a marathon, my lords, Mrs. Goudard was heard. On the 6th day, 15th of November 2013, were filed. And on the 7th day of the trial, oral submissions were furnished. We were then on the 27th of November 2013. So the report from Ms. Godard, the scientist, was ready, and this was to the knowledge of the parties since 24th of May 2011. May I refer your lordships to page 174 of the record. Finally, to make an observation, the Ministère Public has a fundamental role to play in matters of the type with which we're concerned. They are, as my learned friend Mr. Domingue, Senior Counsel, highlighted, the garant de l'ordre public. They are here to ensure that nothing goes wrong. But that doesn't mean to say that they're always right, unfortunately. And I will just draw your lordship's attention to page 700 of the record, to a rather deflated statement from the Chief Justice, Mr. Matadine, who said that at the time submissions were being made before him, before the Court of Civil Appeal, he asked the Ministère Public about their views of the matter so as to obtain guidance on this complex question before him. And he says that he would have expected more from the Ministère Public. So all in all, my lords, it's a simple case. The judge disregarded the only objective proof that was before her, the scientific report. And I've stated my expose before your lordships with a statement from Lord Justice Thorpe, and I propose to end with a quote from Lord Justice Thorpe. I'm reading from paragraph 67 of my written case at page 1300 record. It is again an extract from the case of A and A children, the 2002 English case, and I will read from part of the extract from this judgment. As science has hastened on and as more and more children are born out of marriage, seems to me that paternity of any child is to be established by science and not by legal presumptions or inference. By the judge, in order to stand in the present case, the participant would be long and harmonious trial of the paternity issue when, in the absence of the only decisive evidence, each side would resort to evidence of marginal or doubtful worth in the determination to prevail. In my humble submission, it is exactly what happened. The only objective evidence was disregarded, and evidence of marginal or doubtful worth would prevail. I'm asked by my learned pupil to actually draw your lordship's attention to an interesting point which has been referred to in the submission in the written case of Mr. Domingue of the respondent. At page 1347 of this written case, well, we need to start at page 1346. Mr. Domingue at point J states, Mrs. Godard, however, made a pertinent observation in her addendum report dated 17th of March 2012. This is document D1 you will report. And the observation which is quoted is as follows. If there is other evidence, documents, testimony, that is nearly satisfactory in establishing the relationship, then even a small favorable ... may be enough to make the case convincing. It is my duty to draw your attention to the fact that the piece that has been omitted from this quote is in fact likelihood ratio equals 5. the scientist in D1, when she was referring to small favorable, had a likelihood ratio of 5 in mind, but she actually expressed it on paper. So in our case, the likelihood ratio was 0.0038, nothing near the likelihood ratio which was referred to in this particular part of the report. Unless I can assist further, my lords, I will rest my submissions.
Thank you very much indeed. We're very grateful to all counsel who have addressed us, and to those who no doubt, like Madame de Marigny's pupil, who have assisted behind the scenes, so to speak. May I congratulate all counsel for the excellence of their presentations. The board will take time to consider what judgment to arrive at in this, as I've said at the outset, very interesting, indeed intriguing, but also extremely important case, and we will deliver our judgment in due course. The court is now adjourned. Thank you.